All right, let's review over your tests for this past week. Got a couple of issues that we really need to talk about. I think the first thing is you guys need to spend a little bit more time reading through the lits and the jury charges to make sure that they make sense. I know it can be interpreted sometimes about where the periods go, where one sentence ends and another sentence begins, and I know in court reporting we start with the ands and the buts and the howevers and all that sort of thing at the beginning of a sentence, but we were finding that some of your sentence endings on these tests, even though this was obviously a pretty good test because there was a lot of you that passed it, that you still were not maybe reading it to see when it really did change or where there should be a period. Please remember that paragraphing is always when the subject changes. So we're not counting off on that particularly, but if it doesn't make sense and if the sentences don't tie up exactly right, that could cost you an error on the state test because they're very definite about wanting the sentences to make sense. Arguably, there are some things that can go either way. So, again, a lot of this is client-specific, and it's also firm-specific and person-specific. You'll get 14 different opinions about how to do some things. But at any rate, let's go through it. On June 12, 2014, the defendant finished his work and left at approximately 4:30 p.m. After work, he got a ride to the Village Inn Tavern, period. While there, he made several phone calls trying to find someone who would give him a ride to his car in another city, period. While he was there, he ordered a can of beer and drank approximately 1/3 of the beer. Paragraph. While he was there, he complained of not feeling very well. He said he was having some trouble with seeing double. I didn't realize until I was dictating that several times that trouble and double could be a little confusing for you, but he was having some trouble seeing double. It was at that point in time that the owner of the bar told the defendant that he would take him to go get his car, period. As they left, the defendant took another unopened can of beer with him. Paragraph. The defendant and his wife were having troubles in their marriage. They had, just again, those little double words like that, and had. You're going to have that sometimes. They had many arguments about who would get the car when the marriage broke up, period. It appears that the defendant parked the car in a parking lot in the next town that was across the river so that his wife would not be able to find it and take it, paragraph. The defendant got to his car, and, now it would be okay to put a comma after that and, at approximately 7:30 p.m., he started to his home. He was going north on Route 2. At the same time, Robert Baker and his wife were on the same highway going south. It, page change, appears that the defendant's car, and that's apostrophe S, was gradually crossing the center line. And center line is one word. I looked it up before I gave it, and it is one line in one word in Merriam-Webster. Center line of the highway. He kept moving over into the southbound lane for almost 200 yards, period. It was at that time that he collided head-on with the car that Mr. Baker, and I think in a couple of the tests I did say Barker, was driving. Witnesses at the scene of the collision said that both cars were going the posted speed limit, period. After the accident, one person went over and noticed that the defendant was semi-conscious and that his breath smelled of alcohol, paragraph. The police came to the scene of the accident, period. In the car, they found one open can of beer, which was half full, period. They also found several empty beer cans on the floor of the car, along with 3 empty beer cans on the floor of the car on the driver's, apostrophe S, driver's side, paragraph. The defendant was taken to Three Rivers Hospital where testing showed that he had a blood alcohol level of lower than the limit allowed under the law, period. It was also shown that he had a brain disorder that caused him to black out several times a day, paragraph. The defendant was charged with involuntary manslaughter and was brought to trial, period. During the trial, comma, the defendant's, and again that's apostrophe S, son testified that his father had been having some memory problems for several months before the accident, but that he had not gone to the doctor about it. They also called the owner of the bar to the stand to testify, period. He told the jury that the defendant had complained many times about feeling ill during the months before the accident, period. He had complained of being dizzy and not being able to remember things like he had in the past, period. The owner of the bar was not sure if the defendant had been treated by a doctor or not, paragraph. The doctor who had treated the defendant at the hospital got on the stand to testify that had they not done an MRI, comma, this problem would have not been detected, paragraph. The trial court denied the defendant's motion to dismiss the indictment, comma, his motion to suppress all evidence obtained right after the accident, which showed the presence of alcohol in his system, comma, and all statements made at the scene of the accident by the police officers that indicated that the defendant and his car smelled of alcohol, paragraph. The trial court instructed the jury that the facts in the case did not establish that the defendant was under the influence of alcohol, period. Of course, comma, this did not set well with the state who was trying the case. Now, the state is that entity in that office that is trying it, so it would be capitalized. The trial court instructed the jury to find that the defendant was not intoxicated at the time of the accident, period. Likewise, comma, the trial court instructed the jury to find that the defendant suffered from a brain disorder that possibly did cause the accident, paragraph. The defendant moved to dismiss the indictment, comma, arguing that the state had not proven that he committed any illegal act, comma, other than driving left of the center line, and again that should be one word, comma, because his blood alcohol level did not indicate that he was under the influence, paragraph. Since this condition had not been diagnosed, comma, the court further instructed the jury. Now, this is a legal opinion as such, and so you would definitely be referring to the state and the court in their proper order of respect. A little different sometimes when it's just straight lits and we're talking about, but this is, you can tell from the way they're reviewing the case that this is the legal opinion. Okay, the court further instructed the jury that the defendant could not be convicted of involuntary manslaughter for a death that resulted from his driving an automobile unless the state proved beyond a reasonable doubt that, colon, now most of you didn't get this far, but this is the way that would be put down if you were doing that list. Parenthesis, number 1, the driver knew or should have known about his physical problems, semicolon, and, comma, number 2, the driver should reasonably have seen that his condition would impair his ability to drive an automobile to such a degree so as to harm human life, semicolon, and, comma, 3, his decision to drive an automobile at the date and time and in the place set forth in the indictment was gross negligence, semicolon, and, comma, 4, he was indifferent to his condition at the time he drove the car. Paragraph. If the evidence proves each of these facts beyond a reasonable doubt, comma, then the jury could find the defendant guilty of involuntary manslaughter, paragraph. This came before the appeals court because it was felt that the jury instructions were improper. That's what I think I said improper in the 180. Okay, so that's the literary. Congratulations to all of you who passed that. It's a pretty nice literary. All right, your jury charge. Let's talk again about ladies and gentlemen of the jury. There are as many opinions as there are people on how to do this, but I would like for you to do it the way that it is on this test. Ladies and gentlemen of the jury, comma, and then start whatever, okay? It used to be where ladies was capitalized, gentlemen was capitalized, jury was capitalized, colon after it. Some people put a period after it, but I would prefer that you do it this way so that we could all be consistent. Now, if the firm that you work for or the court that you work for decides to do it another way, follow what they say. There is no written in stone right or wrong way. Old school people will put a colon after it. A lot of people capitalize everything. It's just a matter of preference. So again, those kinds of preferences you will be told about, and if you're not told about them when you go out on the job, you need to ask how they want you to do it, because they'll tell you they have a set way of doing things. All right, so here we go. Ladies and gentlemen of the jury, comma. The evidence comes from the witness stand, from witnesses who have been sworn to tell the truth and who have been examined and cross-examined by the attorneys. Period. You decide the facts based upon the evidence from the witness stand, comma, not based upon the fact that the defendant has been charged or is actually standing trial, paragraph. Now we're changing thoughts. When you came into the courtroom today, comma, you probably knew you were coming to hear a criminal case because of the name of the court. And court is not capitalized there. We're not referring to the bench or the judge. We are just referring to the physical place. So court would not be capitalized there. You might have looked around and wondered to yourself who the defendant was and what he was charged with, period. That is perfectly normal, period. A little change in thought. But if you came in here today and you wondered who the defendant was and what he did, comma, then you are not providing the defendant with his right for a jury to not have a preconceived idea that he is guilty, period. If you think that because he is here, comma, he must have done something wrong, comma, then, comma, of course, comma, the presumption of innocence is not present. Now, if you didn't put all those commas, it reads fine without some of them. Commas are not going to necessarily ever kill you on a test unless it makes the reading of something, unless it changes the meaning of something that you're putting down. This defendant, comma, like all defendants, comma, is presumed innocent until proven guilty beyond a reasonable doubt, period. At this stage in the proceedings, comma, no matter what charges have been brought against him, comma, the defendant is presumed to be innocent, comma, and it will be up to the state, and that would be capitalized, to prove the charges brought against him. The next principle of law, and again, we always have people that mess up the word principle. Please get that straight in your head. Look it up, and when you take the time to look it up and study it, I think it will stay in your head which one to use. It's not P-A-L. So it's the next principle, L-E, of law, that I wish to discuss is the burden of proof. It would have been okay to put burden of proof in quotes if you wanted to, because it's kind of you're fixing to kind of define it a little bit, but it's not necessary. The defendant does not have any burden of proof in this case whatsoever, period. He does not have to testify, period. He does not have to present witnesses nor any evidence of any nature, period. He simply has to be here, period. The burden of proof in all criminal cases rests upon the state throughout the trial. That's one word, comma, and it never shifts to the defendant, paragraph. When the indictment in this case is presented to you, so can you just kind of see when it changes that thought a little bit, that you just put a paragraph there. You should have paragraphs in your lists and your jury charges. It just is unacceptable to not have some paragraphs. Now, are we going to count wrong if you put them in the wrong place? No, not really. Not unless you change the meaning of something by doing that, but that would very rarely happen. Okay, it is my understanding that the defendant will enter a plea of not guilty, period. When the defendant does enter that plea, comma, everything in this case will then be put in issue, comma, and it is up to the jury to decide whether or not the state has discharged its burden of proving the defendant guilty beyond a reasonable doubt, paragraph. If the state does prove each and every element of the offense and proves the defendant's guilt to you beyond a reasonable doubt, comma, then it is your duty as a juror to find the defendant guilty, period. If the state does not discharge their burden and does not prove the defendant to be guilty beyond a reasonable doubt, comma, then it is just as much your duty to find the defendant not guilty. Paragraph. We're changing thoughts. The indictment in this case is for the purpose of setting up the elements of the offense and telling the state what they must prove beyond a reasonable doubt, period. It also has a purpose of telling the defendant what he is charged with so that, comma, when he comes to trial, comma, he does not have to guess or speculate about the charges. There's been a big thread on Facebook here lately, and Margie Wakeman Wells has had a lot of conversation about that word so. So it would not be so, comma, but the way I read it, okay? The indictments set forth in clear, comma, precise language, sets forth in clear, precise language each element of the offense that the state must prove, paragraph. But the indictment, comma, again, comma, is not evidence of guilt. It is merely a pleading that is read to the jury, period. If the state only read the indictment to you and told you that, remember I talked about the had a while ago, was all they had, comma, and then rested, comma, then the presumption of innocence would not be overcome, period. The state would not have met its burden of proof in this case. The indictment, comma, since it is not evidence, comma, cannot be considered by you, comma, and if that is all that the state presented, comma, then it would be your duty to find the defendant not guilty, paragraph. I stated to you a moment ago that the defendant does not have to testify. He can subpoena witnesses, and he can require witnesses to be here, comma, just as the state can. He can present witnesses and testimony if he wants to, comma, but he does not have to. The choice to testify or not testify is a choice that the defendant will make sometime during the trial. If he does testify, comma, he is not different than any other witness. He is not entitled to any more consideration or any less consideration than anyone else who testifies. He is just another witness. If he elects not to testify for whatever reason, comma, then you must not discuss or refer to the fact that he did not testify during your deliberations, paragraph. In other words, comma, if he testifies, comma, then you judge his testimony and his credibility as you would that of any other witness, period. If he does not testify, comma, then there is nothing for you to judge or to weigh. So you may not consider his failure. That thread was really particularly strong about the word so at the beginning of the sentence. So you would not put so, comma. Even though in colloquial English and the way we write, sometimes we like to use that word as a thought process, but it's not used that way here. So it should be so and no comma. So you may not consider his failure to testify for any reason, comma, and you will pass upon the case based on what you have heard from the witnesses that did testify, paragraph. Is there anyone on the jury panel that could not abide by these basic principles of law if you were selected as a juror? Question mark. Again, comma, I assume by your silence that each and every one, 2 words, of you picked as a juror in this case could abide by these 2 basic, there's your principles again, that I have discussed, paragraph. There is one more aspect of the trial that I'm going to discuss with you before I turn the voir dire process over to the attorneys. After this process is completed and the jury is selected, comma, the criminal trial consists of 2 parts, period. The first phase of the trial consists of the guilt or innocence stage, period. The state will put on the witnesses and evidence that they wish to have the jury hear to discharge their burden of proof, comma, and then the defendant, comma, if he has any evidence to offer, comma, will then present his evidence, paragraph. At that point, both sides will rest and close, period. Arguments will be presented, comma, and it will then be up to the jury to determine the guilt or innocence of the defendant, period. If the jury returns the verdict of not guilty, comma, the trial is over, period. That's where I finished. All right. That sure got out of focus. There we go. Okay, here we go. All right, here's your testimony. Question, would you please state your name for the ladies and gentlemen of the jury? That should not be a question mark there. That is a period. So, yeah. Answer, Doris Snyder. Question, are you married, comma, Doris, question mark? Answer, yes, comma, sir. It's okay if you didn't put that semicolon there. If you just put I am, that's okay. But you do have to have either the comma or the semicolon. I prefer, again, that semicolon because the answer really is yes, sir, and then they're adding that I am. Question, how long have you been married? Answer, for almost 15 years. Would it have been okay to write 15 in numbers? Yes, if you wanted to. Question, where do you live? Answer, in Round Rock, comma, Texas. Question, do you own your home? Answer, we are paying on it at the present time. Question, do you have any children? Answer, we have 3 children living at home. Again, the rule, remember, under 10, write it out, so I think it should be written out. Question, are they small children? Answer, the oldest girl is 13. Again, you could have written that in Word if you wanted to. Question, we are here about an accident which occurred on May 14, 2008, semicolon. Is that correct? Answer, yes, comma, sir. Question, what time of the day did this accident happen? Answer, it was around 3:30 or 4. Now that's exactly the way I said it. So in indicating the time, it should have been written exactly like that. I didn't say 4 p.m. I didn't say o'clock. So 3:30 or 4 is exactly the way that should be written. Question, was that in the afternoon? Answer, yes, comma, sir. Question, where were you coming from? Answer, we were coming back home from South Austin, and I gave you that as a capitalized word. Question, did you have business in Austin at that time? Answer, I guess you would say so, period. We are in the dog business, comma, so we went over there to look at some puppies. Question, so that accident happened as you were on your way back home, semicolon, is that correct? Answer, yes, comma, sir. Question, had you already looked at the dogs you were wanting to buy? Answer, yes, comma, we had, period. We saw them on the way home, period. Question, do you do any other type of work at all? Answer, I work as a cook at a place called Childcraft. Question, what is that place of business? Answer, it is a daycare center, and I believe you'll find that is going to be one word. You might arguably say it's 2 words. I don't think we would have counted that wrong one way or the other. Question, how long have you been working there? Answer, going on 11 years. Going back to that daycare thing, generally when you're talking about taking your children to daycare, I think that's always just kind of considered to be one word. The meanings of some of these words have changed they kind of have evolved in our present society, and so I think you could get by with doing it as one word. All right, anyway, what are the hours that you work? Answer, I go in at 9 in the morning and get off at 1. The interesting thing about this construction is that, well, you could have not, if you didn't put the colon 00 or the colon 00 after the 1, if you just put 9 in the morning and get off at 1, I don't think we would have counted that wrong. However, if you ever do the colon 00 for 1 and the other one comes along, it would have to be the same. You just need to be consistent in what you do. Question, is that Monday through Friday? Answer, yes, period. That's the answer. And then she goes on to say, I just mainly go in to help them get the lunch out for the children. You might have had an error on that word, into. It's 2 words, not 1 word, because she goes in to help, not into help. So you got to know the difference between when you use it as 1 word or 2 words. Question, how many hours a week do you spend working with your dogs? Answer, it is really a 24-hour-a-day job. Now, I think, I know 24-hour, and I think -a-day should, 24-hour-a-day should be hyphenated. You might argue that point, and I would listen to your argument on that. I think it would be okay either way. 24-hour-a-day just seems to me like it should be hyphenated, and then the word job. One of them is always needing some type of attention. Question, how many dogs do you normally have at one time? Answer, I think at the present time we have about 18. Again, I put it in numbers. You could write it out, but numbers, because it's over 10. Question, are you trying to place them up for adoption? Answer, no, sir. No, comma, sir, period. We are trying to sell them. Now, it would have been okay to put no, comma, sir, semicolon, we are trying to sell them. Because that really kind of is an extension of the answer. She didn't go off on a tangent on that one. Question, how much do you sell each dog for? Answer, around $400 a puppy. Question, do you like doing this? Answer, yes, period. I have been doing it for 8 years. And again, now there's your under 10, but I think you just have to kind of decide about consistency. So really, if you're going to be consistent, a lot of these numbers are in numbers, then you could put the number 8. We're not going to count off for that sort of thing. I just really would like for you to be as consistent as possible. Question, where do you sell these puppies? Answer, I sell them on the corner where I live. We have a friend who, I think at the 180 we said had, or it should be has a business there, comma, and he lets us set up and sell from his business. I also believe on the 180 we left out the set up and. Question, how hard is it to sell these puppies? Answer, not very hard, period. People love them. Question, getting back to the accident, period. What road did this accident happen on? Question mark. Answer, I don't know the exact address, but it was on, comma, but it was on North Lamar. Question, were you driving north at the time of, I think at 100 I said this accident, or it should be the accident. Answer, I was not driving at that time. Question, so you were the passenger in the car involved in the accident? Answer, yes, period. I don't drive that much anymore. Question about 1 word or 2 words. I think that one could go, I don't know, I think it should still be 2 words anymore. The general rule is that when they stand alone like that, if they're not an adjective modifying something, they are 2 words. A lot of times, I don't want any more dessert. I don't know, either way. I think sometimes when they're an adjective and they modify a noun that follows right after that you can get by with the 1 word. Question, how come? Answer, I don't know. I just don't like to drive in the traffic that much. Question, how many cars do you own at this time? Answer, we only have 1 car. Question, how do you get back and forth to work? Answer, my husband takes me and then comes and picks me up. Question, did you have any dogs in the car with you when this accident happened? The answer is no. You all would have killed me if it had dogs in the car, I think, and they had a wreck. So I said no. Question, so it was just the 2 of you in the car at that time? Answer, that is correct. Question, what were you doing when the accident happened? Answer, we were sitting at a red light on North Lamar. Question, was the light red when you were hit? Answer, yes, comma, it was. Question, what do you recall about the accident? Answer, I just remember sitting there at the light, comma, and all of a sudden, I heard this bang. This guy just rear-ended us at the red light. Question, do you know if he tried to stop before he hit you? Answer, I didn't hear anything before the impact. I just felt it. I don't think he even tried to stop. Question, did your husband see him before he hit you? Answer, I don't think so. He didn't say anything to me about the fact that we were going to get hit from behind. Question, raise it up, please. Did you have your seatbelt on? My able assistant over here. Yeah, there we go. Yes, comma, sir, semicolon, I did. Question, and did any part of your body hit any part inside the car? Answer, I just felt it in my back and in my shoulder when he hit us. Question, what happened there? Answer, it looked like the whole back end of the trunk came up when he hit us. Question, what kind of car were you driving? And that should have been a question mark there. I missed that one. Yeah. Answer, it was a Ford. Question, what kind of car was the defendant driving? Answer, he was in a white pickup, period. I think it was a Chevrolet, period. It was a company truck. Question, was it a sudden jolt to your body, question mark? Answer, yes, period. The impact caused my body to go up and then come back down in the seat. Question, would you say it was a hard hit, question mark? Answer, yes, comma, it was. Question, were you taken to the hospital after the accident? Answer, yes, comma, I was, period. An ambulance was called. You could put a comma there if you wanted, and I was taken to Seton Hospital in Austin. It's kind of a short construction, so not always necessary. Question, did you have insurance at the time of the accident? Answer, yes, comma, we did. Question, after the collision, comma, did you ever talk to the driver of the white truck that hit you? Question mark. Answer, no. Question, did he ever come up to you to see how you were doing? Answer, no. Question, did the police come to the scene of the accident? Answer, yes, comma, sir, semicolon, they did. Question, did they give a ticket to either your husband or the driver of the white truck? Answer, I think they gave a ticket to the other man because he did not have any insurance and he had been involved in quite a few accidents. Those two independent clauses there, actually dependent clauses, because he did not have any insurance and he had been involved. You've got those compound verbs there. I don't think I would separate the and there. I don't think I would put a comma after insurance because of that compound structure there on that dependent clause. Question, what kind of problems are you having as a result of this accident? Answer, my back hurts all of the time. I think I omitted that on one test. It is hard for me to work because of the pain that I have almost all of the time. Question, are you receiving treatment for your back injuries? And that should be a question mark too. I didn't put there. I was sleeping on that test. Answer, yes, comma, I am, period. I go to therapy quite often for the pain. Question, are you able to go to work? Answer, yes, comma, I am still working, period. I have to because my husband is not working, period. Now, I know most of you didn't get this far, but just to show you how it ends up. All we have is my paycheck, one word, and any money we make from selling the dogs. Question, what else were you not able to do right after the collision? Answer, I was not able to do anything at home. Question, what kind of exercise do you do? Answer, I was just told to walk as much as I could. Question, how long has it taken you to get back to your normal way of life? Answer, it has been almost 2 years since the accident. Question, how much damage was done to your car as a result of this accident? And because that was the end of the 225, we just ended it with the answer, it was a total loss. Okay. All right, again, some of those things are up for discussion and for grab, and it honestly will be extremely dependent on how your firm or your judge or the person that you're working for wants you to do it. It's just, I don't know, there's just a lot of different ways that people do things, and it's always client specific. So what your whole goal is going to be is pleasing your client. Well, right now, we're the client. So for the most part, we let a lot of things go, but some of the bigger things we cannot let go. So make sure you get some of those things that we talked about kind of straight in your mind. Particularly, please get the word principle straightened in your mind. I really hate to see you make a mistake and miss a test by one or two words. This particular, I think that jury charge had two times it used the word principle of law. And if you get that wrong, that's two errors. It's really, I just hate to see silly errors. And those are just, to me, silly errors. Now, of course, it's not silly if you don't understand it, but it will be silly if you don't get to the dictionary or get somewhere where they can explain those differences to you, and then you don't make that mistake again. Okay? All of you did very well on this test. I'm just extremely proud of the work that you guys are doing this semester. Okay? Thank you.